I guess I am live. Thank you. Good morning to anybody watching or whenever you're watching, whether it be morning or afternoon or evening or at all. Not legal advice. Please like, subscribe, share, comment, whatever else. This is only opinion, just my thoughts. Hopefully, some entertainment, maybe interesting. Hopefully, so. Going to talk today about a couple issues quickly. I'm going to try to make this fairly short live stream. I'm going to talk about the two things being the Impound Act, which relates to Doge, and immunity relating to FINRA, the SEC, et cetera, and anything else that's related to those things. So good morning to anybody or everybody out there who might be checking this out. I appreciate it. And so I've been talking about Doge being the Department of Government Efficiency that doesn't exist yet, but I guess will exist. And it's not a department. I guess it's just advisory. But part of the job that this non-department department, and I use that term because if it's a department, if it's a regulatory body, then it requires certain constitutional steps to get it moving forward. But it's not a constitutional body, or it's not a regulatory body, apparently. But we shall see. I'm sure that will be litigated. But part of its job is to cut the number of employees, reduce regulation, reduce regulatory numbers, bodies themselves, etc. And so the question is how that's going to be, how is that going to work? And one of the aspects was that these gentlemen, I think Elon and Vivek, would get together, and they probably have gotten together already. They've gone through all the federal departments and budgets, et cetera, and they've made preliminary, I'm sure, they've made preliminary analysis and steps about how they're going to go about it and what to do. But there is something that I have come up with, not me personally, but I've noticed that a concept has been thrown around about another way of accomplishing that, and maybe it would be done in conjunction with Elon and Vivek. Maybe not. I don't know. But the concept is called the Impound Act, and I'm going to Impound Control Act, and I will get back to that as soon as I address a couple of points which I forgot to address, which I should have addressed before we started. So, what do you call a landscaper's bank account? A hedge fund, of course. What do you call a Swiss banker? Franc, of course. And last but not least, what do you call, or what's the most common excuse that FINRA uses to not provide materials? The SEC ate my report. Anyway, so I wanted to talk about the impoundment. So what is impoundment? Impoundment is something that's been around, I guess, since the country existed, not often used, but it's a process, or was a process, by which the president can withhold or rescind spending or expenditures or future expenditures that Congress wants to make. And so, three branches of government: we have the judicial branch, and then we have the legislature and the executive branch. The legislature is the purse strings, and the president, of course, is designed for carrying out laws, et cetera, not in charge of purse strings. So what is the impoundment? Impoundment existed, and it's a process whereby, and let's focus prior to 1974, and you'll understand why I use 1974. But impoundment is the process whereby the president could temporarily delay the expenditures of money that had been already appropriated by Congress. So in the context of Doge, Department of Government Efficiency, non-department, they're looking for ways of cutting number of employees or agencies. So if Congress allocates a certain amount of money to an agency, then under the concept of impoundment, of course, then the president might be able to block that expenditure, and that would kind of go in hand with Doge. So it's been used. It has been used prior to 1974 on occasion. Usually, it's for temporary purposes, just to stop an event or stop an expenditure or some political basis. But it wasn't for permanent cuts. 1974, Richard Nixon was president. Obviously, has an interesting history. And during his presidency, I think it's in 1974, I think, 49 years old at that time. During his presidency, he blocked several programs that had been funded. Some of them, I think, were environmental, but there were several of them. He obviously was in trouble with Watergate. And during that time, the Congress passed something called the Impoundment Control Act. And what the Impoundment Control Act said and says, and it's the Impoundment Control Act of 1974. I think that's the year that Nixon resigned. And it basically says, yeah, President, you can impound, you basically can temporarily block the expenditure of money that's been appropriated by Congress. And understand that Congress has a problem because they get elected every 2 years. And since they get elected every 2 years, they're reluctant to cut spending in their own districts, Republican or Democrat, because they don't want to get voted out. But per this act that was passed in 1974, as a result of probably Congress not being too fond of Nixon, a process was set up whereby the president could block the expenditures and appropriation of monies, but he has to go through a process. And it was only for temporary. And what would happen is the president would send some kind of notice to Congress, and Congress would have 45 days to act, to pass a bill, to rescind the expenditure. But if they didn't act within 45 days, and again, these times are approximate, but I think it's close. They didn't act within 45 days, and some process would go forward, but eventually the impoundment would cease. So it would be, unless Congress approved of the impoundment, which they authorized, the impoundment wouldn't succeed. So apparently during the first Trump administration, with regard to monies that were going to go to Ukraine, there was an attempted impoundment of that for a short period of time. The funds were impounded, but the next administration came in and those funds were eventually released. So there was no real judicial decision about the propriety of impoundment. But apparently now that impoundment is being thought of and potentially might be used as a means of reducing the size of government. And in this case, what will likely happen is perhaps funds will be impounded. Congress will demand or try to release the funds. Maybe the White House will file an action to block, to enjoin that, to enjoin the release of the funds, probably an appeal, and then likely this issue will go before the Supreme Court. And the issue will be, I think there's a decent chance that this is going to be used by the Trump administration. And I think there's a good chance that it will be litigated. And I think there's a good chance it will go up to the Supreme Court to decide whether the president, under his Article 2 powers, has the right to do this over and above what Congress says they can or cannot do. In other words, they would attack the Impound Control Act, say it was a violation of separation of powers of the Constitution, and that the president has the final authority and power to not spend money that has been allocated. And that's going to be the question, and it's going to be a question of separation of powers. But if the president can withhold funding during his tenure, his 4-year period, then notwithstanding whatever Doge suggests, the president himself would have the ability to reduce spending in large sums. Now, those monies might be allocated, they might be appropriated, but may not be spent. And I know part of the problem in government is, and the government agency believes, they don't spend every dollar that they are provided, that their funding will be cut. Probably should be reversed, that to the extent that they don't spend all the money they allocate, that they might be entitled to get additional funds. Maybe the backwards thinking should be followed. So I expect that the impoundment and the Impoundment Control Act will probably become a public issue discussed as soon as Trump takes office in January, because I think it's an idea that's been floated around, and I think it's going to be something that is going to be tried in conjunction with Doge, just by freezing funds, making the courts decide who has power. And again, the court is a conservative court. So maybe the case, now when I refer to the court, I'm referring to the US Supreme Court. It's a conservative court. So it may be the case that the Trump administration believes that they will permit them, they will expand presidential powers or find that presidential powers supersede the the Impoundment Control Act, and that he's entitled to at least hold up spending or something along that. But it'll be an issue, I'm sure, that will be litigated, and you will hear about it. Now you know a little bit about the Impoundment Control Act. Secondarily, and what I wanted to briefly talk about was Doge. So there's part of the process is cutting spending, but part of the process also I'd like to see done, because Doge is designed for, I think in part, and again, I'm not referring to Dogecoin, although I would expect Dogecoin to do very well during this time, but I think that there is going to be an issue, or there is an issue of regulatory overreach. And part of the problem with the regulatory overreach is that the regulators have immunity. And that just doesn't apply to the regulators, but that also applies to SROs, self-regulatory organizations. Now, I had my taste of that through MMTLP, and what we learned is that self-regulatory organizations, which are not even government, have immunity, which permits them to refuse to produce discovery, to participate in legal matters, in cases, just to pretend like they don't exist, but they're not even the government, but they provided the immunity. And the argument is that there is a constitutional issue involving the delegation of responsibility from Congress to private agencies. And there's something called the non-delegation doctrine. And the question is, if Congress delegates authority to a SRO like Finra, it's supposed to be specific in terms of what Finra is supposed to do, and it's also supposed to carefully monitor what Finra does and supervise them. And there was a recent holding in the Alpine case involving a expedited expulsion proceeding where that specifically, the issue of supervision by SEC has come up. So in addition to that, so we have the obligation of government being very specific when they relating to non-governmental agencies. I'm calling Finra an agency for our purposes, but they have to be specifically defined what they can do and how they can do it. But on top of that, they afforded them immunity. So now they don't really closely supervise them. They didn't give a clear grant of what they should do, and they gave them immunity. So in my mind, if they gave them immunity, that should cause them to more closely supervise them and more specifically detail what their duties and responsibilities are and what they can do. But they didn't do that. So in the course of Doge going through the agencies and regulatory bodies, as they're only providing advisory, apparently they're only providing advice to Congress about what to do. I think one thing that they should provide advice is on, and to promote transparency and to clean up the securities industry, is they should remove immunity from SROs like Finra, and they should consider doing that for the regulatory bodies themselves. Now, that doesn't mean that we're not talking about jail. We could differentiate between civil and criminal. So I'm not talking about criminal cases where you're saying they can't go to jail if they commit fraud. I'm not talking about that. What I'm talking about is in civil cases where, a retail shareholder sues a broker but wants to have Finra involved because perhaps Finra was involved in the security that's at the brokerage. As of the moment, Finra can just pretend not participate, not provide documents and information. That shouldn't be the case. That's not transparent. That's not in the interest of anyone, especially not the SEC or us. So my request to Elon and Vivek in their analysis is I think they should also look at the issue of immunity for self-regulatory organizations and for regulatory bodies to impose some kind of burden. I mean, if they act and they make mistakes, that's okay. But if they act intentionally and they commit wrong, intentional misconduct, that is not okay and should not be permitted. And they should not be immune from that. The agencies themselves and the individuals committing the intentional acts. Again, I distinguish between errors and misconduct. But either way, if there's actionable problems, we should have the ability to pursue relief against these non-governmental agencies. There's no reason not to. And again, their ability is they could get insurance. They can go out in the market and buy insurance to cut down any risk. It should be their obligation, like it is for all business, all private companies. If you have a risk, you pay for it, pay to cover and hedge your risk by buying insurance. And that's what FINRA and other self-regulatory agencies and perhaps regulators in general should be obligated to do. So I would my request is to Elon, et cetera, is to look into removing or suggesting, advising removal of immunity so we can get to the bottom of misconduct in a much easier fashion. And again, if there's nothing to hide, then there's nothing to hide. This really doesn't make a difference. And again, it doesn't treat the government any worse than retail shareholders. We're the ones who are not treated with the appropriate respect to this point in time. So those are the two things I wanted to talk about. We talked about the Impoundment Act and how that might play into Doge, and we talked about immunity and how that might play in. My next topic, I'm not going to talk about it today, but I'll talk about it in the next couple of days. I wanted to talk about federal preemption. In other words, when can the federal government kind of step on the states, even though this particular administration, I think, is going to be big on states' rights. When can they, and how does that relate to like full self-driving, Tesla, et cetera? So we'll do that next. Hope this was helpful. I'm sure you will see more about the Impoundment Act and perhaps about calls for immunity or to remove immunity. Anyway, hope you all are well. Take care. Be well. I tried to make this a little shorter today. Have a great day. See you soon and be well.